If your paycheck is currently being garnished for student loans, or if you're afraid it's about to be, then this question really matters. Can bankruptcy stop the garnishment of your paycheck for student loans? And the answer is yes, it can. So let's go into it here. So while we may be able to get the garnishment stopped, it may not wipe out the debt. It depends on the facts of your case. There is something called the student loan adversary. If your loans meet certain conditions, then an adversary can be filed during the course of your case, and maybe you can wipe some of it out, or in rare cases, all. But yes, when you file a Chapter 13, the automatic stay will stop all garnishments because for many people, the immediate emergency is the paycheck, rent is due, groceries are due, car insurance is due. The garnishment is what breaks the monthly budget. So in this video, I want to walk through three things in plain English. First, how student loan wage garnishments work in 2026. Second, what bankruptcy does the moment the case is filed. And third, what bankruptcy usually does not do unless you take the extra step of asking the court to discharge the student loan for an undue hardship. What we talked about a second ago about doing an adversary. So here we go. When most people hear the word garnishment, they think of a creditor suing them, getting a judgment, and then taking part of their wages. A private student loan can do that, but federal student loans are different. If you're in default on many federal student loans, the government can use what is called an administrative wage garnishment. That means your wages can be taken without first filing a lawsuit and getting a court judgment. And in general, this amounts to about 15% of your net pay. So it's actually less and better than when they actually do go and get a judgment. But it still can feel super sudden and really aggressive. In 2025, the Department of Education announced that collections on defaulted federal student loans were resuming, including Treasury offset against tax refunds and then administrative wage garnishment after that. Later in January 2026, the department announced a delay in involuntary collections to give borrowers more time to evaluate repayment options. So if you're hearing mixed messages in 2026, that's probably why. Collection policy has been moving around. But here's a practical point. If a garnishment notice is active or about to become active, you need to act based on your real timeline, not headlines, not rumors, and not what happened during the pandemic pause. Can bankruptcy stop the garnishment? Yes. In most cases, when a bankruptcy case is filed, the automatic stay goes into effect immediately. The automatic stay is one of the most powerful protections in bankruptcy. It generally stops lawsuits, foreclosures, garnishments, and most collection activity. Federal authorities also recognize that bankruptcy can prevent collection by garnishment, including through the automatic stay. So if your wages are being garnished for student loans, filing bankruptcy can usually stop that garnishment from continuing while the stay is in place. That is the first major answer. But now we get to go to the second answer. And this is where people often get tripped up. Stopping the garnishment is not the same thing as eliminating the student loan debt. Those are two different fights. A lot of people assume if they file Chapter 7 or Chapter 13, the student loans go away with the rest of the debt. Usually, that is not how it works. Student loans are generally non-dischargeable in an ordinary bankruptcy case unless the borrower proves undue hardship through an adversary. And that's still the rule. The discharge question is separate from the stay question. So let me say it clearly. Bankruptcy can stop the collection pressure now. Bankruptcy does not automatically wipe out the student loan balance. If you want the student loan to actually discharge, you got to file that additional lawsuit called an adversary inside the bankruptcy case and prove the undue hardship. It's a high bar, but it's not as high as it used to be. There currently is some guidelines from the U.S. Department of Justice, and they have been fairly agreeable. So it's possible, but it's not automatic. Now, let's talk about two chapters most consumers ask about. Chapter 7, that is the fast liquidation bankruptcy. In court, out of court, bang, you're done, debt's wiped out. It can be effective when the goal is to stop collection activity quickly and discharge other unsecured debts like credit cards, medical bills, and personal loans. That can free up cash flow and make the student loan problem more manageable, even though the loan itself survives. The automatic stay arises when the case is filed, but the case is relatively short in Chapter 7, so that protection it's not permanent. And typically, those cases will be finished and done with in about 90 days ish. Chapter 13 is a repayment plan. Many people like to call it the catch your breath provision of the bankruptcy code. It's for people who they've got some money to pay the creditors back. They just can't do it all tomorrow. We need a little more time. We need time to catch our breath and breathe. And this can be useful for people with regular income who need longer protection from creditors, need time to catch up on other obligations, or need a structured payment plan. Get everything consolidated into one single payment to cover your car, past due arrearages on the house, and we can get rid of credit cards, medical bills, and all that other unsecured debt in one single payment. While the Chapter 13 case is active, the debtor is protected from garnishments and other creditor actions. So, from a wage garnishment standpoint, both chapters can help. The difference is usually about the bigger financial picture. What other debts are in play? What other assets need protection? How stable is income? And is the borrower trying only to stop the garnishment or also in a position for a possible student loan discharge case? What bankruptcy does immediately. If somebody is dealing with a student loan wage garnishment, the first practical benefit of bankruptcy is usually speed. Once the case is filed, the stay goes into effect right away. That can stop the employer from continuing the garnishment process. Now, this is very important. Bankruptcy is not a time machine. Money already taken before the filing is usually a separate issue. The main immediate benefit is stopping the future collection activity, not automatically clawing back every dollar that has already been withheld. So if somebody is on the edge and the garnishment is about to hit the next paycheck, timing matters. This is not drama. This is just how the system works. What if you actually want the student loans discharged? Well, that's conversation is getting a lot more serious. If the goal is not to just stop the garnishment for a while, but eliminate it or part all, then we're talking about an undue hardship case. And the Department of Justice and the Department of Education has put into place guidance intended to make it easier and more consistent for qualifying borrowers to seek discharge of federal, keyword, federal student loans in bankruptcy. It is a streamlined process. It's not super fast. It can generally take at least, 6 to 9 months ish. And every case is different. So I want to emphasize this is not super easy, but it's a process that's way more realistic than it has been in the past. And that's the major difference. So for the right borrower, especially someone with a long-term financial hardship, chronic inability to maintain basic living expenses while repaying, age-related limitations, disability-related limitations, or other persistent barriers, it's definitely worth evaluating. But again, do not confuse these two things. Filing bankruptcy to stop the garnishment is one move. Litigating to discharge a student loan is the next move if the facts support it. Bankruptcy is not the only tool. Sometimes the best first move is to get out of the loan default through a rehabilitation or a consolidation or pursue other administrative solutions if one applies. The key is, what is the big picture? What does the big picture look like? Are student loans the only problem, or is there credit card debt, medical bills, things that really would help the overall situation if we could take care of those? The Education Department's 2026 announcement specifically referenced more time for borrowers to evaluate newer payment options once they consolidate and enter a rehabilitation agreement, and that also referenced a second chance to rehabilitate defaulted loans under the new law described in that announcement. There are also special situations like borrower defense claims or total and permanent disability discharge where collections can be stopped or the loan can be addressed outside of bankruptcy. So the old fashioned lawyer answer is still the right one. And what answer is that? And the answer is it depends. Depends on the facts. If the borrower just needs the garnishment stopped immediately and also has a pile of other debt, bankruptcy may be the strongest tool. If the borrower's main problem is the student loan itself, then there are solid non bankruptcy remedies available, and those need to be reviewed as well. So, what's the real takeaway? Here's the practical takeaway. If you are asking, can bankruptcy stop student loan wage garnishment in 2026? The answer is yes. Usually it can because the bankruptcy filing triggers the automatic stay that generally stops garnishments and most collection activity. But if you are asking, will bankruptcy automatically erase my student loans? The answer is usually no. For that, you're looking at an undue hardship adversary proceeding, and whether that's worth it or not depends on the specific facts of your case. That is the straight answer. No magic wand, no myth, no shortcut around the legal standard, but also no reason to assume you're out of options. Because for the right person, bankruptcy can be the move that stops the bleeding, restores cash flow, and creates breathing room needed to deal with the student loan problem right away. If your wages are being garnished for student loans, or if you've gotten notices, you think the garnishment is next, the worst thing you can do is freeze up. Don't bury your head in the sand. This problem is not going to go away by itself. Get the facts, look at the timing, look at whether the loans are federal or private, look at whether the real goal is short term protection, long term discharge, or both. Because once you know the problem you're solving, your path usually gets a whole lot clearer. And in 2026, that is still the rule. Bankruptcy can stop the garnishment, does not automatically finish the entire student loan fight. Thank you so much for tuning in. Have a good one.